New polls provide insight into whether Beto O'Rourke's gun control strategy is working in Texas. Plus, an interview with George Mason University's Robert Leider on a new federal gun rule. That and more on this episode of the Weekly Reload podcast.
I made the devil run. I gave him poison just for fun.
All right, welcome, ladies and gentlemen, to another episode of the Weekly Reload podcast. I'm your host, Stephen Gutowski. I'm also the founder of thereload.com, where you can head over and sign up for our free weekly newsletter right now. At the website, you get a roundup of all the most important gun news of the week, just one email in your inbox on every Friday, and you'll be caught up on what's going on. If you want even more in-depth analysis about the goings-on in the Guns in America, you can buy a membership as well, and you'll get an extra newsletter on Sunday. You'll get exclusive access to hundreds of pieces of analysis and exclusive stories that you won't find anywhere else. And you'll get an opportunity to listen to this podcast a day early and appear on it. We actually have a member segment this week, so I'm looking forward to that. It'll be at the end of the show if you want to stay tuned and hear from one of our members, which is something I always enjoy doing. But before we get to all of that, we have our main guest. Professor Robert Leider from George Mason University is kind enough to join us this week and talk a little bit about some of the post-Bruen goings on in gun law and litigation. So welcome to the show.
Well, thank you very much for having me.
And can you tell people just a little bit more about yourself and some of your credentials on Second Amendment? You're obviously very well respected on this topic, and you've done a lot of work in the area.
So I'm an assistant professor at George Mason University, Antonin Scalia Law School, and I started researching this topic in graduate school. I did a PhD in philosophy and wrote my dissertation on the right of self-defense. So most people agree that self-defense is permissible, but coming up with a sound philosophical justification for why it's permissible and why it's permissible under the narrow limitations that it is actually quite difficult. And so I studied that in graduate school. And then from there, I went to law school and then clerked for Judge Sykes on the Seventh Circuit and Justice Thomas at the Supreme Court, and practiced for a few years on both sides of the clerkship. And then academically, I started at George Mason, and I've been here ever since. And I've been writing on the right of self-defense, why political authorities can use force to have compliance with the laws, for example, the fleeing felon rule, and also on gun control and the Second Amendment. So I'm doing it both from the Second Amendment side and from the military side. And so my latest paper actually talks about how we should be translating the modern armies and militia to today.
Yeah, so you've been very busy in this field, and you have a lot of experience on this topic, which is exactly why I wanted to have you on to talk more about a couple of developments, starting with a new ruling out of Texas in federal court that strikes down the felony indictment gun ban. To this point, the Federal Firearms Act had prohibited people who were indicted for felonies from receiving firearms while they were under indictment. And Judge Counts, in this case, determined that there was not a historical analog that he could identify, which would give credence to this restriction under the new Bruen standard. So can you just give us your first reaction, maybe explain a little bit of the implications of this particular ruling?
So federal law prohibits a number of people within a number of categories from even possessing a firearm. And so these are, the felon in possession ban is the most commonly known. There are some others, such as the misdemeanor domestic violence ban, and people who are unlawfully using drugs and so on. In addition to that, federal law has a prohibition that says those who are under indictment for a felony may not receive a firearm, but they may continue to possess firearms that are already owned. And so these are individuals who a grand jury has found probable cause to believe that they've committed a felony and they're heading to trial. And so they're in this kind of in-between status that they can't receive a firearm, they can't transport a firearm in interstate commerce, but they can possess and presumably carry it within their home state, subject, I suppose, to any restrictions that are placed on them as a condition of bail.
Yes, it's kind of it's an interesting, it's an interesting derivative of the felon in possession ban, because it's applied to people who haven't actually been convicted of anything yet, although they are going through the court process. But
They are, and convictions,
and that does come up as a distinction in this ruling, right?
Yeah, no, I mean, it's definitely, I mean, it's kind of intermediate state that they are awaiting trial or in trial. If they are convicted, they will lose their gun rights under federal law. The Supreme Court has assumed, although not with any real justification, that the felon in possession ban is constitutional. It has repeated those assurances, even though there are no historical analogs to that. Those were 20th century creations that, depending on exactly when you want to date it, you're either from the 1930s or 1962 or maybe 1968, a couple dates that, can be floated around depending on exactly which law you're referring to. But there's no analog in the 1700s or 1800s. And so they're kind of in this middle ground, and federal conviction rates are famously high. So most of the people who are indicted will in fact be convicted or plead guilty and will lose their gun rights. But while they're in this middle stage, they can possess but not receive.
Right. And I guess in this case, the defendant had, he lied on the background check form. That's what he was ultimately actually convicted of. Because he was under indictment when he bought his firearms, but he hadn't yet been convicted, and so. But I don't know. Do you? I guess one question I got on Twitter was actually, do you think the judge went too far in even deciding the legality of the Federal Firearms Act when the actual crime was lying on the background check?
Well, there's also a materiality question of whether it's not a crime just to lie. The statement has to be material. And so I don't think he went too far in doing that. But I don't think he went too far in looking at it.
Okay. Yeah. So that's important. Like, he's not necessarily going well beyond what the scope of the case is. Although he does go beyond just the felony indictment section of the Federal Firearms Act. Mainly, he does this because the government argued that the federal indictment prohibition was linked to the felon in possession ban historically, and that basically the government's argument was, well, this is the same essentially as the felon in possession ban, and Heller said in one paragraph that these are longstanding and presumptively constitutional. So therefore, the felony indictment prohibition is also constitutional. The judge rejected this argument, and part of the reason he rejected it is that he views the felon in possession prohibition as not longstanding, despite what the Supreme Court said, and having no historical analog. Do you think his analysis there is correct? Or, obviously his laws, as you mentioned, only date back to the early 20th century, and really the federal indictment provision only dates to the mid 20th century, the 1950s. So is the judge correct in his assertion that neither of these relatively substantial restrictions that are popular among most Americans are actually historically grounded?
The judge is correct. I mean, this is one of the questions that comes up in Heller and Bruen's aftermath. Heller just says in dicta that the felon in possession, that nothing in the opinion should cast doubt on the felon in possession ban, but it never explains why. And those assurances have been repeated ever since. They were repeated in McDonald. They've been repeated by various judges in Bruen, by various justices in Bruen, but never with an explanation for why. And Kevin Marshall actually wrote this wonderful law review article, Why Can't Martha Stewart Have a Gun?, where he goes through the history and notes that there was no historical analog of these felon in possession bans. And I think there are two things to note about the history. Number one, there were no bans that applied to felons as such. These are, as you indicated, mid-20th century creations. The second is that the definition of a felony is much broader today than it was at common law. So common law, early common law, there were very, very few felonies. These were like murder, rape, robbery. And then felony, the definition of a felony originally was anything that would result in the forfeiture of your lands and estates. And in the 1800s, this gets, the forfeitures die out, and a new definition comes in that's any crime punishable by more than 1 year in prison. But since then, the theoretical statutory maximum, a lot of crimes have gone up. And so you have a lot of crimes that are essentially misdemeanors, but have as a theoretical maximum penalty 2 years, 3 years, 5 years. And so the definition of a felony today is much, much broader than anything it would have been historically either. And so what you have are a lot of people who are falling within the ban, but who in substance have really done what I think traditionally would have been viewed as a misdemeanor rather than a felony.
Yeah. And in fact, I think Judge Counts goes perhaps even further than just felon in possession, to essentially point out that there really wasn't much of a historical record of taking anyone's guns away.
No, the people whose guns were taken away in the early days were either people who did not, individuals who did not fall within the people, namely the political community. So these would have, at the framing, been enemy aliens, American Indians, free blacks in a lot of states where there was an open question, at least till Dred Scott, whether they were within the people. And you see in New York, in some of these cases that they're citing these gun bans as evidence. The second is that during the wars, people who were in actual rebellion were disarmed. And so that was a second category. And what the government has been doing in a lot of these cases is trying to string together these bans and say, well, there's this broad principle that anyone the government deems as dangerous can be disarmed. But that's much broader than the original bans were. But they're trying to basically adapt Bruen's historical test to what was the previous intermediate scrutiny test by just taking it at a very, very high level of abstraction and just saying the government can disarm anyone who's dangerous. But Bruen doesn't say it goes quite that generically.
Right. Yeah. I think that's going to be a big fight moving forward here, is the level of review and this sort of how far back you need to step to find an analog. And it's going to raise a lot of serious questions about basically every gun law. It seems, especially the federal gun laws, which didn't appear until the 20th century. And so it's interesting that's why this particular case, I think, is really noteworthy, because it's one of the first to take a stab at some of these federal gun laws. And it does cast a lot of doubt on them, but then it also offers up a potential solution, right? And you sort of touched on it there, which is the Judge Counts talks about how, the Second Amendment is reserved to the people, like several other rights in the Bill of Rights, the First Amendment, the Fourth Amendment. And but at the same time, those historically, there were subgroups excluded from what was considered the people. And they were, in some cases, felons, and others. So it's a bit more of a, I think, substantial place to root your argument than just the Native American and Catholic bans that you've seen New York cite, and on even Justice Barrett at one point. So I don't know. I'm interested in your thoughts on this particular tact that Judge Counts is taking in this case. Do you find that to be a persuasive argument for why felon in possession bans could withstand the Bruen test if you use this sort of argument that there are certain subgroups that aren't included in the people?
I still don't think that would work. I mean, I think felons have traditionally been included in the people, and they have lost some of their political rights, but not traditionally their right to bear arms. And I think there are two problems here. One is that the analogy doesn't quite work here, and the second is, as I indicated earlier, the definition of a felony is so expanded that it covers crimes that aren't really within the scope of what a felon would have been at common law. I mean, somebody who mails a handgun commits a felony. There are all kinds of these technical regulatory offenses that
Sure.
Are punished by 2 years instead of 1 year, but they are in substance a misdemeanor. And I don't think the history would justify everyone who has committed a crime punishable by more than 1 year, no matter what the mental state is. A lot of these are strict liability or crimes that have fairly low mental states because they're regulatory offenses. Many are nonviolent. I just don't think that the history will bear out that all felons of every description are subject to the ban. Now, in the early days of the Gun Control Act, there was a restoration provision. There still is technically on the books a restoration provision that said that those whose gun rights were suspended could apply to the Secretary of the Treasury, now the Attorney General, for restoration of gun rights. But for the last 30 years, Congress has not funded that and has told ATF not to process those. And I think that's going to also raise as applied questions that even if which has happened, there have been a few of these, and they've gotten less traction than I thought they would. But I think you will have people who will say, look, I have been convicted of a nonviolent felony. Maybe even my nonviolent felony would have been deemed a misdemeanor at common law. There's no evidence whatsoever that people who have done what I've done are violent. It's way in the past. You should restore my gun rights. And traditionally, there was an administrative process to do that. Now those people without that administrative process are probably going to re-raise it in the courts and say that the felon in possession ban is unconstitutional. And even if it's constitutional, it's unconstitutional as applied to them. And
Right.
I'm curious what will happen with that. I really have no idea.
Yeah, I mean, I do. Clearly, there's some appetite among the justices for a nonviolent felon challenge to that law because, obviously Barrett had the dissent in a nonviolent felon case where she argued the prohibition on nonviolent felons is not constitutional, at least. But I'm interested. You seem to agree with Judge Counts' historical interpretation that there isn't a good historical analogy to either the felony indictment or felon in possession ban from that dates only to the 20th century. But at the same time, my understanding is you don't think this is going to be upheld on appeal. Why is that?
Courts have difficulty being too counter-majoritarian. And as you noted at the outset, this is one of the most politically popular provisions. That felons just don't have a political constituency that advocates them having guns. And this is one thing both sides can agree on. And I think courts will find it difficult to cut that far against popular opinion. One of my early Second Amendment articles, I kind of looked at what courts, especially state courts, had historically done here. And what I found was that courts often declared unconstitutional laws that were extreme or went beyond what the popular mainstream was at the time, but that they didn't go ahead and radically rewrite a whole bunch of state laws. And so when you had states early on prohibiting the carrying of concealed weapons, they said fine. When you had one or two states like Georgia in the early days say, well, we're going to ban all public carry, they said, no, that's too far. But they also accommodated the desire for regulation. There was an early case in Kentucky called Bliss versus Commonwealth that said the Second Amendment was absolute and not capable of any restriction. And that was uniformly repudiated by the other courts and eventually by Kentucky through constitutional convention. So I think courts, just as a matter of kind of legal realism, courts strike down laws that are particularly extreme, but they generally don't go against the mainstream opinion in this way. And I think this is not the only one. There are other laws. I was doing a debate, and Darrell Miller, who's at Duke, brought up that, no matter how they interpret the Second Amendment, they're not going to authorize people to carry weapons aboard commercial aircraft. And that's, another example where finding an analog is virtually impossible. You could most certainly have a gun in your carriage or, is subject to the common law crime of going armed to the terror of the people. But, to say that a particular mode of transportation was out, I don't think will happen. I think the other thing that's interesting about the felon in possession, the indictment ban, is that it doesn't also reach the concurrent and supplementary power of courts to put reasonable conditions on bail. So even if this were struck down, I think the judge would still have power as a condition of bail to say, well, you're not going to possess a firearm or don't go out and buy a firearm. I have trouble imagining that, if Osama bin Laden had been captured and transported back to the United States, well, I guess he wouldn't have been allowed on bail. But, if somebody who's very dangerous would have been allowed on bail, they're going to say, well, unlimited power to buy guns until the jury verdict comes in. I don't think it's going to happen. And I think it's a mistake to say that every regulation has to have a historical analog. I think, Justice Thomas in his majority said this is not a regulatory straitjacket. You have to analogize a little bit. And I think, there was going to have to be some adaptation to new circumstances and to new types of laws. And I think you're seeing some of the growing pains here. Now, one last thing, the good side of the growing pains is that by causing a division of opinion in the courts, you may see more attention from the Supreme Court. One of the things the Supreme Court does as its core mission is to keep federal law uniform. And so as circuits split on issues, they will step in. They had not stepped in the Second Amendment space for a long time because no court ever struck down a law on Second Amendment grounds. And then you had the DC Circuit do so in Heller when Heller was in the Court of Appeals, and then they got involved. Then there was a circuit split and they had to get involved. So the fact that there may be differing opinions may give the Second Amendment more attention from the federal courts.
Yeah, certainly. And I'd expect there to be a lot of differing opinions on a lot of these issues from here on out because they're dealing with an entirely new standard of review. And that's sort of what Judge Counts' point. He repeated a number of times talking about, known unknowns and unknown unknowns and, trying to work his way through this case with the just historical analog as his guide. And, he didn't seem to like that. I'll be honest. There's a number of comments in his ruling about, for instance, the difference between disarming somebody in the 18th century versus the 21st century, where he argued at least that firearm ownership at that time was much more vital to basic survival than it is today, was one of his arguments for why, there might not have been the same sort of exact historical copies of these types of laws, because disarming somebody completely at that time was viewed as, almost a death sentence. And at least this is his argument. I'm sure there's probably a lot of people who might disagree with how he comes down on this, but that was one of his explanations for why you don't see some of these laws at the period. Obviously, there's all the reasons that you laid out there as far as things have changed quite a lot in how we apply criminal justice since that time, specifically in wildly expanding what a felon is. But, and so he's trying to apply the standard faithfully and then also offer his view of how you could move forward with potentially upholding these laws under the Bruen standard in a way that wasn't presented to him as an option it sounds like the government didn't put a whole lot of effort into this case. At least that's the way the judge makes it sound. They didn't really offer him quite a lot of really any evidence of beyond surety laws, which are really quite different from gun bans, ownership bans or purchase bans, to support this idea that the law is historically grounded. So he kind of came up with his own explanation. I think you're going to see a lot of judges do that, and that's how things are going to work themselves out. But by the time it makes it to the Supreme Court, they're going to have a couple different options for and how these things should be interpreted under that text and tradition standard that Justice Thomas laid out in Bruen. Do you think that's a fair view of how this is all going to eventually proceed?
I think that's a fair view. So one thing about Bruen, there was a lot of law on the right to carry arms after the framing. This is it just happens that Bruen is on a topic where they were in state courts under state constitutional analogues, but the courts were treating the state constitutional analogues as coextensive with the Second Amendment. And so Bruen, in applying a test, had a lot of law to work from. That is not the case for a lot of these novel provisions. And so what you're going to have, I think your analysis is right. I think you're going to have two sets of challenges. You're going to have challenges from gun groups that are very targeted and very sophisticated. But you're also going to have a lot of challenges from criminal defendants. And, excuse me, the challenges from criminal defendants may be more or less sophisticated depending on how much time the public defender has to research it. And so from that end, when you get these less sophisticated challenges or less sophisticated responses from the government, you may see judges trying to do their homework and fill it in. Yeah. But that's always difficult for the judge because one of the advantages of being a judge is that you should have the parties present the issues and then you get to decide. When you go off on your own and do research, there's always the risk that there's something you don't quite understand. And I think the second thing that's hard about this is just how to adapt history to today. And there aren't good answers. A lot of, as your questions indicated, and it's true, a lot of the fundamental assumptions of the framing generation have changed. And it's not always clear how you apply originalist methodology in the face of fundamentally changed assumptions. That requires some effort at adaptation or translation. And I think to go down that path is difficult and controversial. And I think you'll see judges do it very differently. I think aided by the fact that the gun issue is so politically salient that judges, depending on their personal priors, are going to view the cases very differently. Yeah,
of course. And I think that's all extremely valid. But of course, the balancing tests present the same sorts of issues anyway for judges. It's not.
It may be worse.
Yeah, perhaps even more so.
Yeah, no, I think the big problem with the balancing test is that judges could just kind of say, well, public policy, we're going to just defer, which is what they did, and just say we're out of it.
Just defer to the government every time.
I think the biggest problem right now with the Second Amendment in terms of doing the sort of historical approach is that we don't have a coherent conception that people agree on about what the Second Amendment is supposed to protect. So I think we see some switch right now from having some military related value to being for civilian self-defense against crime. And the kind of open question at the moment is whether this individual self-defense has superseded the military related objectives of the Second Amendment or are supplementary to them. And answering that question is going to get you a very different set of answers in terms of how you look at things like so-called assault weapons bans and magazine restrictions. If you say, well, look, the Second Amendment's designed for individual self-defense and we're banning a narrow category of weapons, then, you may say, well, these laws are constitutional. If, on the other hand, you take the Second Amendment as seriously in its statement that it's trying to provide for a well-regulated militia, then targeting weapons because of their perceived military characteristics is very problematic. So I think, I think Heller doesn't really answer this, and it's not clear where the courts are going to go on this, but I think this is sort of the most fundamental question that's laying out there at the moment, and judges will ultimately need to answer to figure out which way to go.
Yeah, and we could do a whole podcast just on on that topic, and maybe we should. But right now, I wanted to focus a little bit on gun carry. You brought that up earlier. One of the things that you've been writing about and sort of warning about, or at least talking about how it's been undercovered, is the New York's new gun carry law and the way that it sort of flips the presumption of where it's lawful to carry a firearm. So in every other state, it is presumed that you can carry inside of a public business if they don't post a sign indicating otherwise. But now in New York, they've done the exact opposite of that. Now it is a crime to carry, and also a lot of states don't make it a crime to carry where it's posted necessarily, at least not that isn't a specific crime in a lot of states. But in New York, it will now be a crime to carry in a location that doesn't post that they want people to carry there. And this is a pretty significant change and I guess innovation in the gun control space, and one that you think is, this novel approach is going to be challenging for gun rights advocates. Is that right?
I think it's going to be very challenging for them. So Second Amendment is a claim against the government. It is not a claim against private businesses or other private property holders. And so, it's pretty clear that if private property owners want to keep gun owners out, they can do so. The question is, how do they do so? Is the default rule going to be that you're allowed in unless you're told to leave? Or is the default rule going to be that you're not allowed in unless you're specifically invited? And, the default property rules have been traditionally that in private homes, you really should be invited onto the property unless you're just walking up the door to knock. There's often an implied invitation for that. And that for businesses, it's the opposite, that you can come on unless you've been excluded. There are a few states, including South Carolina, I think, and Louisiana, that say you can bring your gun onto private businesses unless you're excluded, but you can't bring them into somebody's home unless you ask permission. So some of the pro-gun states have some sort of restriction, at least in some cases, saying that there's a presumption that you're not allowed to bring it in. Now, the New York innovation is to combine private property with the power of government by saying you are presumed not to be able to bring it in anywhere, and you're going to be guilty of a felony if you do so, not just a trespass. And I think this is a very hard issue, because it is for conservatives. It's at the intersection of gun rights and private property rights, both of which they believe in. In terms of the Second Amendment doesn't. There has been there's been very little law on what the presumption has to be. The closest analog I can think of this is that Alabama in the early 1900s prohibited possessing a pistol on property not one's own. And the Alabama Supreme Court actually upheld the prohibition. So that's the only case law that I think is analogous to this. But I'm not sure the Second Amendment says anything about what the default rule is either way. And so I think gun rights advocates, from what I've read online, I think that this is an easy case because the practical implication is a de facto ban on public carry, which it is.
Right.
But I don't think it's quite that easy given how they've co-opted private property. I think it was quite an ingenious way to do it. But I'll let you follow up with that. But I have more to say on why it may still be unconstitutional.
Yeah, I definitely want to hear that. I just, obviously, I think the main argument is that you've seen mostly is gun rights advocates focus on the fact that this law is really an attempt to just make gun carry off limits everywhere, in basically a direct.
And they've in fact done that. People in upstate New York are far worse off today than they were under Bruen, because before Bruen, licensing policies were at the local level, and at least geographically, most of the counties were shall issue in practice. And the irony of the may issue states was always that it was uncertain and potentially difficult to get a license. But once you got a license, you had pretty wide freedom of what you wanted to do with it. That guns were always more restricted in the South and in the pro-gun areas. than they were in a lot of the may issue states. It was hard up front, but once you got through the gate, there were no restrictions on bars or public transit or any of this. States have come back, and a person who has an unrestricted pistol license in upstate New York after Bruen and after this law is far worse off than before Bruen.
And you saw Governor Hochul there, the Democrat, basically say that admit that there'd only be a few places where it would be legal to actually carry a gun after this law went into place, especially in New York City. And so that, I think what people in the gun rights community have noted is like that is just a complete and total, middle finger to the Supreme Court, because they're basically just doing exactly what the court told them they can't do. And so I think people view this flipping of private property or public business access on its head to be part of that, and just consider the whole law to be unconstitutional. And there hasn't been a whole lot of discussion about why that particular novel approach is unconstitutional. So, I am interested in what, now that you've laid out the risks, why do you think it's not necessarily going to stand up?
I think there's a middle approach here. So, the kind of two stock positions right now are that either it's constitutional because the default rules aren't constitutionally mandated, or gun rights advocates are challenging these laws and saying, well, there's no historical tradition for doing this. But I think there's a middle approach here that, what New York is doing in some ways is analogous to how Southern legislatures acted after Brown versus Board of Education ordered the desegregation of schools. And so what you saw after Brown was massive resistance, including legal resistance in a few different forms. Now, what's interesting about the New York law is the New York law does not actually flip the presumption. We've been saying this, but it's not actually true. And if you look at the law is heavily gerrymandered. So the law does not apply to police officers or other law enforcement officers, including those who are off duty, and it doesn't apply to retired law enforcement officers. So the law is gerrymandered only against license holders. Now, if you really flip the presumption, what that would mean is that no one would be authorized to bring a gun without explicit consent, except for officers who were justified in committing what would otherwise be a trespass. So an officer who had a warrant or was in hot pursuit of a felon could go onto private property without the owner's permission. But a police officer getting a coffee and a donut on a break would have no authority to go against the private property owner's wishes. And with, a fortiori, an off-duty officer, and even more so, a retired officer who has no law enforcement powers whatsoever, has no authority to go on private property against the owner's wishes. So if New York were truly flipping the presumption, then the presumption should apply across the board, except in those cases where the officer would be justified in committing a trespass. So they've heavily gerrymandered this law. And I think that's somewhat analogous. If you go back to what the southern states did after desegregation, the orders came down, there were a couple different versions of this. And one version is some of the states passed laws saying, well, we're going to abolish public schools. But when we abolish public schools, we're going to give you tax breaks for private schools, and there's going to be a lot of government participation in these private schools. And the Supreme Court said, no, you can't evade the desegregation order by, quote unquote, privatizing your schools while still maintaining what are, in essence, de facto public schools that they have heavy participation. And on the other hand, there was a case that involved the desegregation of public pools where Jackson, Mississippi said, well, you know what, we're not going to run a pool system at all. It doesn't matter what race you are. We're out of the pool business entirely. And the court said, well, if you're out of the pool business entirely, we'll let you do that because you're not required to run a pool. You're not required to run public pools. And we realize that some of the people who voted for this had pernicious motives. Some others may have legitimately believed that the pools wouldn't have been economically viable. We get that. We're not going to go into the motivations that much. If you're going to have a neutral law that says no pools for anyone, fine. But if you're going to gerrymander your law to create a de facto public school system that has the guise of private schools, that just violates our remedial decree, and we're going to order you to stop doing that and to reinstate the public schools. And I think that middle position may have considerable validity here. If New York really wants to flip the presumption, it can do so, but it has to actually flip the presumption and tell law enforcement officers, no, you cannot go onto private property unless you're invited. But if they're going to gerrymander the law only to make it impossible for license holders to carry guns in public and no one else, that just seems like a flagrant disregard of Bruen. And so it may not be all or nothing. There may be this middle ground, and this middle ground may be advantageous to gun owners because, of course, there may not be the political will within the legislature to tell retired police and others and off-duty police that, no, you will commit a felony if you bring your gun on private property without permission. So I don't think this is an all or nothing thing. You're right that they are thumbing their nose at them, but there is a kind of precedent on how you handle this. And so there may very well be a middle position here that is not one or the other.
That's interesting. So so the police carve-outs, which are pretty common to a lot of these strict gun laws, of course, you see that as a sort of Achilles heel for these.
Yeah,
for this particular reform.
Some of these may be justified. So some of the theories on off-duty police officers carrying guns, is, at least if they're in their jurisdiction, is that they are authorized, even though they're not on the clock, to make arrests and to intervene, and so it gives added police coverage to the jurisdiction. I think it's more problematic when retired officers are just given special privileges. So you see in a lot of the assault weapon bans that they exempt retired police officers from the ban on assault weapons and magazine capacity restrictions. And those, I think, are hugely problematic. These officers do not have police powers. It's just basically a special interest carve out for them. And in fact, the Ninth Circuit actually, when it found against the individual Second Amendment right, actually struck down the retired law enforcement officer carve out of the federal assault weapons ban. But that decision never got much traction beyond the Ninth Circuit.
All right. Well, I think that's fascinating. We'll have to look for more from you on this topic, because I think you're right. I think this is a novel approach that's going to be a significant problem potentially for gun rights advocates, and one that's has a lot of potential to spread beyond New York to the other former May issue states as well. I wouldn't be surprised if it cropped up in California and Massachusetts and Illinois and elsewhere. We'll have to wait and see how it plays out in court, but I'm looking forward to reading more from you on the topic, and perhaps having you back on the show again in the near future. But until then, where can people find more of your writing?
So I have a couple of different places. My academic writing is on SSRN, and you can find me by looking me up there. I also have a blog where I deal with the more day-to-day issues called Standing His Ground. And so you can go to www.standinghisground.com, and my blog deals with anything from the right of self-defense to gun control and the Second Amendment. And I have plans to blog about this issue and also about some of the new FedEx and UPS policies. And I will say, it's kind of my parting shot. I think for gun owners, the most significant regulation these days are coming from private parties, not the state. And we see that with some of the credit card coding and some other things that, even as gun owners are winning in court right now, the vacuum is being filled with private regulation, and that private regulation may be much stricter than anything that legislatures can pass.
Yeah. We just did a podcast with Larry Keane from the National Shooting Sports Foundation on that merchant category code change, so people can head over and listen to that. But we're going to head over now and do the news update. So,
all right. Well, thank you.
All right, ladies and gentlemen, it's time for the weekly news update. I'm contributing writer Jake Fogelman, joined as always by Reload founder and host Steve Gutowski. How are you this week, Steve?
I'm doing good. How are you doing, Jake?
I'm doing pretty good. Got a couple big stories that are going to be highly relevant, I think, for the upcoming gubernatorial race down in Texas. One is a new poll to kind of show where things are at between incumbent Governor Greg Abbott and the Democratic challenger, Beto O'Rourke. If you want to tell us a little bit about what that poll found.
Yeah, we have a couple polls, it's like 2 or 3 of them that came out recently in that race. The first one, which was I believe it was the Texas Tribune and the University of Texas at Tyler, they found that Abbott now has an 11-point lead over O'Rourke, which is just a point off from his biggest lead in that poll to date, back from even before O'Rourke won the nomination. So, and it's, an expansion of his lead from the last poll. It's not a huge expansion. I think it's about a 1-point expansion, but it did bring the Real Clear Politics average for the race up to, I think it was like 7.8. So significant lead for Abbott going, into the home stretch here. We're almost at October, which is, of course, the last real campaigning month of the year. We still have another week until then, but it is an important indicator in the race that this is not really getting any closer, despite Beto O'Rourke's focus on gun control policies. He's stuck with that focus. He's really still emphasizing the need for more gun restrictions in his mind, and that has been really a central point of his campaign. It's obviously not the only thing that he's running on, and I don't know that the race is. Abbott wants to focus the race on things like immigration, of course, but O'Rourke has tried to keep guns at the top of mind for Texas voters, and it just hasn't really worked out for him so far.
Yeah, no, I think that's the key. We've been talking about this for at least a year now, about now that he's running statewide in Texas again, will he or won't he stick with his gun control message? Obviously, it's, I guess, popular knowledge would suggest that that's tough sledding in a state like Texas. But as you point out, he's stuck with it through the campaign trail. He's flip-flopped a bit, but in terms of his exact position, but he's generally hit that issue pretty hard. And as you said, it's not really paying dividends, it looks like, at least in the polling.
Right. I mean, he has changed his tact, I will say, obviously. He doesn't talk as much about his confiscation plan. He's gone back and forth on that, like you mentioned. He's obviously very well known for saying he wants to take everyone's AR-15s and AK-47s. It's one of the reasons this race is particularly interesting for us, right? I mean, Texas is, or at least the saying, or maybe the delusion, I don't know at this point, is that Texas is trending bluer over the years, and somebody like Beto O'Rourke has, a possibility of flipping the state that has traditionally been a Republican stronghold. That's sort of the big idea that going into this race, and has been for a while with O'Rourke, even though he's continually lost these campaigns despite a lot of outside help, a lot of excitement from around the country in Democratic areas for his campaigns. But the other big reason is that there's a huge stark contrast between O'Rourke and Abbott on gun policy, right? I mean, O'Rourke is one of the furthest left of any major candidate across the country. Like, he really literally wants to confiscate people's firearms. It's not a theoretical thing. He has said so very definitively. Now he's backtracked on that, and then gone back and doubled down on it, and then backtracked and doubled down. His campaign website still says that he doesn't believe anyone should be able to own AR-15s and AK-47s. But his message on guns doesn't focus on that anymore. It focuses on, he spent a lot of time focusing on this idea that Greg Abbott should call a special session to look at new gun restrictions, specifically banning anyone under the age of 21 from owning AR-15s and AK-47s and other firearms, under the sort of assault weapons banner. And so he's tried to shift to that point. Abbott has said that that's not constitutional, given some of the recent rulings on restricting firearms rights of 18 to 20-year-olds, which Abbott has corrected. There have federal courts have been trending against that in recent years in a couple of cases, as we've covered. But the polling indicates that people in Texas are open to that policy more so than they are to banning or confiscating AR-15s. We had another poll this week that showed a majority of Texans oppose an assault weapons ban. And so, it's sort of another poll in that vein of evidence that the assault weapons ban is becoming less and less popular in the United States. Certainly Texas is a little more gun rights favorable than a lot of other states, but it's still interesting to see that. And it's perhaps one of the reasons why Beto is not doing quite so well.
I was just going to say, I think that possibly speaks to why Abbott's lead might be growing slightly. As you said, it's only a point or two, but it's still growing, while around the country you're seeing these races where, a few months ago we thought there's this red wave, there's this talk of this red wave, and you're starting to see a lot of those races narrow. And in some cases, in swing races, you're starting to see a little bit of a Democratic edge. So I think that is interesting that while that's going on in a state that, the wisdom that's been talking in DC that, Texas is turning blue, Texas is going to turn blue. Well, you're starting to see it spread apart the other way, where the Republican is still retaining and even gaining on his advantage. And as you said, that Siena College poll that found a majority of Texans oppose an assault weapons ban, I think that at least plays some part in that. I think it's safe to say. Yeah,
I think so. Interestingly, the Texas Tribune poll found, I think it was like 53% support for mandatory buyback. So, and obviously, a lot of Texas polls are not that divergent from national polling. Now, obviously, that Texas Tribune poll asks about mandatory buyback of assault style weapons. It doesn't none of these polls give a definition for what they mean by assault weapon or assault style weapon, and these are obviously nebulous terms, as we've talked about a lot in the past. But certainly, they apply to at least ARs and AKs, but generally, while definitions vary significantly from state to state, in assault weapons ban statutes, they certainly cover a lot more than ARs and AKs. But either way, that language between banning assault weapons in the Siena poll and a mandatory program of buybacks from current owners in the Tribune poll might also cause a little bit of variation there, because maybe people don't, laymen might not understand what a buyback is.
Right.
Hopefully people would understand mandatory buyback means you don't have an option and it's confiscation essentially, but that might explain some of the difference. Also, there's what does banning mean? That could mean confiscation as well in theory.
True.
Usually people mean it to say no new sales. But again, these pollsters don't provide any definitions to the people they're asking these questions from. So, there's a little bit of ambiguity that goes on with some of these results. But I do think that, there's certainly evidence in the polling that Texans want stricter gun laws, or at least they say they do. And so that should open up. And Cato's policies that he's put forward aren't, wildly unpopular in these polls.
Sure.
So there ought to be more space for him to gain on this issue, but the polling indicates it's not what's happening. I believe there was a third poll, I believe, that we covered.
Oh, yeah, the Dallas Morning News, I believe.
Yeah, the Morning News poll, which found, and I might be mixing up some of these, so make sure you go to the Reload and
read
actually
the piece.
read the piece. But it's a lot of polls, and it's a lot of University of Texas involved in like every one of these polls for whatever reason. But they found that Abbott and O'Rourke are tied on who Texans believe would handle gun violence better. So he's not really gaining an advantage. And then, of course, multiple polls also found that guns are not a top priority for voters, even in Texas, where you had the Uvalde shooting happen. It's still ranking fifth in one poll and sixth in another poll as far as, top issues in the race that are influencing people's votes. So that's probably a big reason why he's not gaining a lot of ground, even though he might be taking the positions that Texans say they agree with more often in the polling. It's also something that's not really motivating people, and they're not really sure of him, it seems like.
Yeah.
Even if he's saying policies, he's supporting policies that they say they agree with. Maybe they don't trust him in particular. I don't know. It's interesting.
That's sort of a phenomenon we've covered in the past too, sort of the disconnect between polling that suggests people support something pretty strongly, and then when push comes to shove and a vote needs to be cast on it, it doesn't always work out the same way that the polls suggest. You know, we've seen that with ballot referendum, for example, in various states on gun control measures. So it's quite possible that's what's going on here as well.
Yeah. That's the thing about polling is like you gotta, it's not necessarily that the poll is skewed or done wrong. Obviously, polling is not an exact science. There's a bit of art to it. So, you're not necessarily going to predict everything perfectly or line up perfectly with reality. But it's more an issue of like, just because somebody says something in a poll doesn't necessarily mean that that's their top priority or that they even necessarily understand the question, or that it's going to motivate them to vote a certain way. And so, you got to examine these polls with the proper context. And, I think if you look at the breadth of the polling on this race right now, it says that while people might have a generalized desire for more gun control because perhaps they think it'll help prevent things like Uvalde in the future, they're not that sure about it. They're not that committed to voting off of it, and they don't necessarily trust Beto O'Rourke to carry it out the way that they'd like to see done. We'll continue to follow that race, and I think it's going to be one of those hallmark races for how gun politics plays out, because it's also one of the areas where you have a major race that does have guns as a top issue, where that's not really true so far in a lot of these other races. Although Everytown did just buy a $1 million ad campaign in Wisconsin against Senator Ron Johnson, the Republican there. So, we're getting into that period where we're going to see election spending really explode. And so we'll be on top of that as well and start to cover some of these other races and how they're playing out in terms of gun politics. Because there's just been so much that's happened since the last election that really affects gun politics that it's not really clear how things are going to work out. I mean, you had record gun sales for 2 years in a row with millions of new gun owners who are from demographics that are not traditionally Republican voters necessarily. You had the Supreme Court's Bruen decision, which has massive implications for gun laws throughout the country. But you also had things like the Uvalde shooting, right? It was one of the worst shootings in American history. And you had the House pass the assault weapons ban the first time in 30 years. There's a lot that's going on that we need to wait and see how it's going to play out politically.
Right.
What the new state of play for guns in America is. You had a brand new federal law, the first new federal gun restrictions in decades as well. How is that all going to play out in the elections? And that's what we're trying to find out by following some of these key races. So we're going to stay on top of that. But that's it for now. We're going to head over to our member segment. We have a member segment this week, so I'm pretty happy about that. And we'll go over there now. All right, we're back with a member segment this week. We have Reload member Bobby Mercer with us. Welcome to the show, Bobby.
Hey, thanks, Stephen. Glad to be here. Thanks for having me.
Yeah, absolutely. We appreciate you joining the show and doing a little bit of an interview with us and giving us just some insight into who our Reload members are. Because I think we got a pretty wide variety of people who subscribe, and I'm always interested to hear everyone's stories. Now, we met actually just recently at the Liberal Gun Club's Virginia event out at the Cove out in Western Virginia, but not before you get to West Virginia, but it's Western Virginia. And I spoke to your group, but you're a member of the Liberal Gun Club, right?
I am. And I'm now the treasurer of the Maryland, DC, Virginia chapter.
Oh, okay.
Yeah.
So can you just tell people a little bit about the Liberal Gun Club? I'm sure it sounds weird to some people out there.
Right. Well, it's one of the things. It's just what it sounds like. It's a place for left of center people who are interested in firearms to come together. There's a big social aspect of it where we just like to hang out, and we do that online. We do that in person. We go shooting. We have range days. People have trainings, and there's instructors. And then there's also a political component where we lobby. We have a lobby day that we go to, and I was involved in this year's one for that, and trying to especially give people who are left of center politically a voice in the firearm discussion in this country.
Mm-hmm. Yeah, and I think counter to what a lot of conservatives might assume about you guys, you're not for necessarily new gun bans or anything like that. There's a certain stereotype about liberal gun owners in conservative circles that they're sort of they're like FUDs, right? Is the common term you'll hear, where they want to have their guns, but they're okay with banning a lot of other guns. But I don't think that's really a good description of where you guys fall on the spectrum. I
would agree with that. No, we like guns, and you've hung out with us, and we like to shoot everything. And we are specifically for like Liberal Gun Club, as far as like our stance on things, is we are big proponents of root cause mitigation, actually going at social issues that drive violence, rather than like, as we say, like blanket gun bans or magazine capacity things, or other kind of like what I think we term like window dressing or band-aids. Like it's sort of I think it's fair to say it's kind of like a reaction. So that happens, people react, and they kind of, the only thing that you're given, especially if you're a left of center person, like if you're not in the firearms community, you're like, oh, gun control. And it's like, it seems like the media sort of gives you that one answer, that traditionally conceived gun control is the answer to violence and to the things that happen that are terrible events. And as gun owners, we're kind of like, well, we don't really think that that's true. And we think we have the data and evidence. If you actually research it, it's like, no, there are other things that are more important. It's like homicide rates are more closely related to the inequality, the Gini index, than anything else. So I think we are probably, and I'm not a spokesperson for them, but I think it's, giving
but this
people,
gives a good insight into why you joined.
Right. Yeah. It's like,
your personal.
Yeah. So it aligns with a lot of my own views of, giving people resources to thrive, and giving people, believing in giving people access to things like healthcare and, good schools and violence intervention programs, and basically supporting communities and having that as being sort of, and reducing inequality.
Still very much a liberal worldview,
right? But
you just disagree on firearms.
Exactly.
Yeah,
exactly.
That makes sense. So you don't like Trump and McConnell, but you like Smith and Wesson.
Man, you read my mind, Stephen. I'll have to remember that one.
But so what was it that got you into firearms in the first place?
Well, I think I'm a combination of like the traditional gun culture and then what people call like gun culture 2.0. So my access to firearms I didn't grow up with guns in the house, but as a teenager, I got into, me and my dad really started bonding over liking firearms, going to the range. And like, that was like one of my best memories of being a teenager, was like fall's coming, right? The fall, Sunday morning, the air is cold. You go outside, it's the smell of the range. It's the feeling at a time, like just having time with your dad and that kind of a thing. That was really what got me into firearms and into enjoying it. And that was my start. Life went by. I didn't shoot guns for a good period of time, and I moved to the West Coast, and I came back because of some family health issues. And then eventually, when my parents passed, I got my dad's guns. So now, this was, a number of years ago, but all of a sudden I had these again, and it was like, man, I remember when we used to go shooting, and I remember what that felt like. And I was holding these things that my dad had held, and it was that connection again. So I wanted to go shooting more, and I realized I like it. I never lost it; just life went in a different direction, and it came back.
Sure.
So that was that traditional part of being into firearms. But the more modern part was the political climate changing. 2020 happened, pandemic, social unrest, and that got me into thinking more in terms of like self-defense and having that kind of a connection with things. With rising violence against marginalized communities, my partner's a person of color. So it's like one of the reasons, actually the reason I got a concealed carry permit isn't really for me. Like I probably would have got one, but what really made me do it was like, when things are said about immigration, it has or anything like that, where you get, let's be scared of brown people, black people. It has an effect of radicalizing certain people. So it's like, I'm like, well, if somebody, it's like having a viewpoint of, if you decide to avail yourself of your Second Amendment rights, I think, I believe you should be able to do that. And so choosing to, if we're walking down the street, if somebody wants to do something because they've been emboldened in some way. So that kind of thinking is what really got me into the self-defense aspect of it, and sort of that.
And that was more recent.
That was more recent.
So
that
you
was
didn't
like
get your concealed carry license until just recently.
Yeah, 2020.
That makes a lot of sense. Yeah, I mean, and you're clearly not alone on that front of reconsidering that the purpose of firearms ownership and some of the self-defense aspects of carrying a firearm even. And so is that when you joined Liberal Gun Club and started to seek out other people who maybe also enjoy guns but still have that similar worldview as you?
Yeah, especially during the pandemic, because it's all online. And if you go on YouTube or you go onto, gun channels and things like that, it tends to be very conservative or, sometimes it's neutral, but there tends to not be a lot of spaces where you can feel like you can talk about your worldview and talk about firearms without it turning into something else. So that's where I found, I actually don't even remember where I found, I probably searched, where do liberals who shoot guns get together in Google or something? I probably did that. And I was like, come on, there has to be something out there. And that's where I found Liberal Gun Club. So it was online at first, but then, we've met in person since the pandemic has eased up. And then that's where I found out about the Reload, was actually through them. And then I met you. So, yeah.
Okay. Yeah. No, and I've been to, obviously I've covered the Liberal Gun Club for a couple of years now. And I've even been to the national conference. I believe your national conference is coming up in a couple of weeks, right? Out in Las Vegas.
It is.
And I went to the one in Florida a few years back. And, one of the interesting things to me about what I heard from other members was that, you have people in the gun community who are very conservative and are not open to the idea of liberals owning guns, or they're very dismissive of it, or they think that they're, out to take away their firearms rights, as we discussed earlier. But you also have a lot of people in the liberal side of things who are very disapproving of liberals owning firearms as well. And that's actually another, some of them said that was even more of a reason why they wanted to join Liberal Gun Club, and that they kind of keep secret the gun owning part of their lives from some of their liberal friends because of the stigma. What has your experience been with that?
It can be. Yeah. It can be something where, well, it's like in any circle of people, if you know people's views on things, or you at least, maybe you don't know, maybe it's an opportunity where we should actually just talk to each other more. But if you think you might have an inkling of how people are, you might not be the first thing you say to them. It might not be something that you bring up in conversation. And also, it's not a shared interest, so it might not be something that comes up anyway. But I think a lot of our audience, as like the political side of Liberal Gun Club, and I can't speak on behalf of the club, but from my perception, at least, it's a lot of it is Democrats. It is people who may not even be aware of the statistics that we can show them, who also may not have anybody who's able to speak to them. And it's kind of like the tone that you bring to this show, which is one of the reasons why I heard it and I subscribed, because it's just a more, it's not neutral, but it's like, it's fact-based. It's nobody's screaming. And if you're trying to have a real conversation, you can just talk. And I think that a lot of the politicians have people screaming at them. And when we show up and we're like, hey, we just want to talk to you about this. And it's also, I think, giving people the benefit of the doubt. Like, some people are just deeply anti-gun and you're not going to change them. And that's true with anything in life. Right. But there are other people who are like, no, I actually didn't realize that this was that. And I just sort of, this just sort of went along with the other views that were sort of just floating around in the air. And if you can talk to them, reasonably, you can get through. So yeah, I think a big part of our audience is trying to talk to, because we feel like we see that they're not seeing the whole picture. We're like, we understand that you're trying to do the right thing, but we also see that the way that it's going about isn't giving you the results that you think it's going to. Yeah.
It's interesting. The liberal gun club is kind of one of these ports in the storm of polarization to me, where like you have each side and they dug in on a very, very stringent view of how people who own guns ought to think and look and act. And and you guys seem like you're in a space where you don't necessarily fully agree with this side or that side. Like maybe you agree with a lot of conservatives on what their views of guns, but not on a lot of other issues, and maybe you agree with a lot of liberals on the other issues, but not on their view on guns. And so you're these sort of an independent-minded group that is very unique in that sense to me. And I think it gives you a certain, like you were talking about there with when you go and speak to Democrats, for instance, just take Virginia, for example, maybe Democrats will listen to the NRA or the Virginia Citizens Defense League, but some of them are probably going to be unwilling to even hear those groups out because of the aggressive nature of how they undertake gun advocacy, whereas they might be more willing to listen to you guys on the same issue. And I think that's an interesting advantage that you guys have created in the political realm. And then, of course, there's the whole social aspect of it, which I think is even bigger, really, than the political advocacy side of what you guys are doing.
No, I agree with that completely. I think there's probably a level of trust when there is a lot of value overlap and you're able to say, hey, we see things the way that you do, but here's something that we see a little differently. So there's, you definitely, I think you can come across in a different way when you can sort of meet somebody at that place. Which
probably helps in at least to some degree with overcoming that polarization and persuading people. But yeah, so it's one of the reasons I've always found the Liberal Gun Club to be a really fascinating institution. And I think we're seeing more and more groups like that crop up. The National African American Gun Association would be another example of a group that is, has the same basic views on guns as the NRA or GOA or these other groups, but is directing its message at a specific group of people who don't feel included all the time in the gun rights community, just from speaking with them. And so it's interesting to see the rise of these sorts of groups as gun ownership diversifies and expands.
Yeah, and talking about polarization, we try, and I think it would do a legitimate effort at. It's not like you have to have all the same views. There's a lot of diversity and a lot of debate that happens in our group. There are people that have very different, from middle of the road, just a little left of center, to very far left, to people who don't even know and, may not even want to define themselves in that way. So we try to be, open-minded, to everyone and have it being an open and inclusive sort of place.
Yeah. Absolutely. And so you found out the Reload from getting involved with the Liberal Gun Club? What was it that made you decide to become a member?
I think I became a member after listening to just one or two episodes. I think that the guests you have on are very knowledgeable. They were very, they let me, I felt like I learned a lot, but I think it was you, Stephen, the way that you let people talk. But then if somebody says something that is a little bit, I don't know how to say, out there, or if it's a little bit demonizing, or if somebody is trying to write somebody off, you will, say, hey, you'll not call them out explicitly, but say, hey, is that really a fair assessment, because these other people over here have that. So I feel like you guide the show in a way where it ends up being a place where people still feel like they can show up, and it doesn't become like, I feel like everybody can listen to it without feeling like they're going to be beat up on or something like that. So I feel like I really appreciated that, because it's, especially in a polarized issue like gun rights or something like that, all too often that you don't really get that.
No, thank you. Yeah, I mean, that's what we try to focus on, keeping things sober and serious, right? The catchphrase, our tagline or whatever. But
Yeah.
Yeah, I think it's something that's very important to me as far as the show. Something I think that it can set us apart a bit from other offerings out there surrounding, gun politics. And so I'm glad that that's what appealed to you, and I hope it appeals to other people too. And it has so far, right? We're doing well. We're not, I'm not a millionaire or anything, but we are doing well, and we are getting a lot of support from the readers and the listeners. And I greatly appreciate that, because it's the only thing that makes it possible. Your membership and everyone else's membership who's signed up thus far is the only form of income we have at the Reload now. And it's something that sustained us, and I'm hoping can grow us into a even larger platform in the future here. That's my goal for the Reload long term. So hopefully other people are as enthused about it as you are. And if they are, they can head over to thereload.com today and pick up a membership and perhaps appear on the show, the next member segment. That's my hope. And if not, if you're not in the position to make a purchase today, I think you can support the show by sharing the podcast, sharing our newsletter, sharing our stories, rating the podcast on whatever platform you're listening to it on, whether it's Apple Podcasts or Spotify or what have you. Those things all help tremendously for us. But of course, it is members like Bobby who are the ones that sustain our publication. So I just wanted to say thank you, Bobby, for coming on the show and for being a member.
You're very welcome. Thanks for putting on the podcast. And thanks
Absolutely.
for asking me.
Yes, thank you for joining. That's all we've got for this week. So make sure you stay tuned. We'll be back soon.